Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. For those online, we remind you you're welcome to send questions or comments at any time, simply emailing speaker@heritage.org. Our task for those in-house is to make that courtesy check that our mobile devices have been silenced or turned off as we prepare to begin. It is always appreciated. And of course, we will post the program on the Heritage homepage for everyone's future reference following today's presentation. Leading our discussion will be David Azrad. David serves as the AWC Family Foundation Fellow here at Heritage. He is also director of the B. Kenneth Simon Center for Principles and Politics. Please join in welcoming him. David?
Thank you. Welcome everyone to the Heritage Foundation for this final event in our annual Preserve the Constitution series. All the previous events, including the Joseph Story Lecture by Judge Brett Kavanaugh of the U.S. Court of Appeals, can be found on the Heritage website. We have before us an interesting and important question. Was the American founding conservative, liberal, or libertarian? But before we can answer it, we must first establish what it is that we mean when we speak of the American founding. Many scholars, you see, deny that there is an intellectually coherent American founding. The American founding, in their retelling, is but an amalgam of various disparate political and religious traditions that are often at odds with one another. Instead of a founding, what they leave us with is an incoherent mishmash of classical liberalism, the Bible, English constitutionalism, classical republicanism, all sprinkled with a dash of the Scottish Enlightenment too. In his impressive new book, The Political Theory of the American Founding, Natural Rights, Public Policy, and the Moral Conditions of Freedom, Thomas West definitively refutes this view. He makes the most compelling and thorough argument that I know of, at least, for a unified founding anchored in natural rights and natural law. It is not only the best book written on the founding in recent years, but also one of the best on the subject, period. And we are very glad that Tom is here with us today to present his argument and to offer some thoughts on what the founding means for us today. That is, to put the intellectual framework of the founding in conversation with the three most prominent contemporary political worldviews in America. And we are also glad to have with us Randy Barnett and Bill Galston to offer their views on Tom's book and to respond to his arguments. Our speakers are well known, yet I will still briefly introduce them. Thomas West holds the Paul Ermine Potter and Don Tibbets Potter Professorship in Politics at Hillsdale College and is also a senior fellow at the Claremont Institute. Before joining Hillsdale in 2011, he taught at the University of Dallas for almost 40 years. The Political Theory of the American Founding is his third book. West is also the author of Vindicating the Founders, Race, Sex, Class, and Justice in the Origins of America, as well as the editor of several other books on political philosophy and American political thought. I should add that he is also a noted translator of Plato and Aristophanes. Randy Barnett is the Cormac Waterhouse Professor of Legal Theory at the Georgetown University Law Center, where he teaches constitutional law and contracts. He is also the director of the Georgetown Center for the Constitution. Barnett's publications include 12 books, more than 100 articles and reviews, as well as numerous op-eds. His most recent book is entitled Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. Bill Galston holds the Ezra K. Zilka Chair in the Brookings Institution's Governance Studies program, where he serves as a senior fellow. A former policy advisor to President Bill Clinton and to presidential candidates, Galston is an expert on domestic policy, political campaigns, and elections. He's the author of 8 books and more than 100 articles in the fields of political theory, public policy, and American politics. His newest book, entitled Anti-Pluralism, The Populist Threat to Liberal Democracy, is due out in March. Tom?
Thank you very much, David, and thanks to our panelists, Bill and Randy, too, for being here. I'll start with an overview. The book has 3 parts. The first is on the founders' natural rights and natural law theory, which includes topics like equality, liberty, state of nature, consent, government structure, and the major foreign and domestic policies that, in the founders' mind, were necessary to secure our rights on the basis of a politics of consent. As far as I know, this kind of in-depth treatment of all of the elements of the founders' theory is not available in the scholarship anywhere. Parts 2 and 3 of the book go into two major policy areas. On the one hand, promotion of virtue, and on the other, property and economics. These two areas may be loosely defined as conservative and libertarian, and they are major examples of policies that are, again, meant to secure our rights. In Part 2, I show there that previous accounts of the founders on morality have either been too brief or have failed to stress sufficiently the connection between liberty and good character in the founders' minds. Almost all libertarians today would reject the founders' approach on these topics, especially when it comes to their support for lifelong heterosexual marriage through laws forbidding no-fault divorce, discouraging sex outside of marriage, and promoting different roles for husbands and wives within the family. Conservatives today generally say they believe in the importance of marriage and morality, but they tend to be very cautious and somewhat timid, I would say, when it comes to promoting policies that actually might be supportive of those ends. As for liberals, liberals do agree with the founders that the government has a major role in shaping the moral character of the people. But liberals have a different view of what moral means. They believe government should teach toleration and respect for what the founders would have called immorality or irresponsibility. Liberals want to teach people to believe in government programs that take jobs, money, and respect away from groups that have too much privilege, as they say, and give them to groups which are either less successful on average or which have traditionally been treated with less honor and less respect. Part 3 of the book explains how the founders' natural rights theory shapes their policies on property and economics. This is a crucial part of the founders' infrastructure of liberty. Property law belongs to what scholars call the liberal side or individual rights side of the founding. I want to clarify some of what is distinctive in the founders' approach and also what scholars have tended to not notice through 5 examples. First is the meaning of liberty. In the state of nature, liberty means being left alone, not being coerced by others. It means people may do as they please, subjected only to the law of nature, the law that requires you to treat other people with respect with regard to their individual rights and the integrity of their life, liberty, and property. Under a just government, therefore, liberty means that people should be free to organize their own affairs as they see fit. To show how controversial this is and how little known, I add that in the founding it was taken for granted that an employer and an employee have a natural right to exchange money for labor on any mutually agreeable terms. No one denied that private clubs and schools may establish any criteria of membership they like, however discriminatory, in today's sense of that term. Today's government regulation of the terms of membership in private associations is said to be necessary to protect civil rights, on the ground that otherwise bigotry and oppression will prevail. Today's conception of civil rights would have been regarded by the founders as a violation of civil rights, the civil right and the natural right to liberty. Not today's conception of civil rights in all ways, but in the way I just mentioned, in regard to the internal governance of private associations. And that is what Madison meant when he said in Federalist 10 that taking away liberty to abolish faction, to abolish selfish organizations, is like depriving people of air to breathe as a way of preventing the outbreak of fires. Liberals today would not accept the founders' view of liberty. No prominent conservative would accept the freedom of association principle in domestic policy. A few libertarians would embrace the founders' view, although one often has the impression, I hope to be corrected on this if it's wrong, that many libertarians would much rather avoid topics that are too outside the current liberal conservative mainstream of ideas. this view of, and I'm not going to name names, this view of liberty applies directly to the founders' view of immigration. And that's my second example. Today, many believe that the founders' idea of liberty and equality means that America is what is called a proposition nation, which anyone has a natural right to join. Many scholars take for granted if you agree with the founding on their equality principle, then limiting immigration from third world countries is, quote, not who we are, unquote. The Emma Lazarus poem, "Give me your tired, your poor, your huddled masses yearning to breathe free," is treated as if it were a paraphrase of the Declaration of Independence. The founders disagreed. In the Massachusetts Constitution, for example, quote, "The body politic is formed by a voluntary association of individuals. It is a social compact," unquote. The compact, as the Massachusetts goes on to say, requires consent on both sides. In another paraphrase of this idea in the founding, between the society at large and each individual who wants to be a member of that society. Otherwise, the demand to become a citizen of a society would be, if it were something that the majority was not allowed to reject, would be a violation of the equal rights of those who are already existing citizens, who exercise their liberty collectively by consenting to the laws they are to be governed by, including those specifying what immigrants will or will not be invited. Liberal scholars, like Roger Smith, believe that limiting immigration by race or national origin is, quote, quite obviously illiberal, inconsistent with the ideals of liberty and equality professed in this nation's creed, unquote. Many conservatives, such as Paul Ryan, Ben Sass, and so on, would agree with Smith. On the contrary, as Gouverneur Morris observed at the Constitutional Convention, quote, "Every society, from a great nation down to a club, has the right of declaring the conditions on which new members should be admitted," unquote. In the case of immigration, the right to discriminate is nothing more than an exercise of the right to liberty itself. Third example, matter and form. There's a failure to understand what I call in my book the relation between matter and form in the founding. Some scholars, particularly neoconservatives, argue that America is constituted solely by an idea, the idea of equality in the Declaration of Independence. The culture, religion, and traditions of those who are settled here, or of those who are invited to immigrate, are therefore considered to be irrelevant. Other scholars take the opposite view. Paleoconservative Russell Kirk, for example, denies that abstract principles have anything at all to do with the founding. For the neocon and liberal propositionists, it is all principle and no tradition and culture. For Kirk and conservatives of his kind, the founding is all tradition and culture and no principle. The founders disagreed with both positions. In Federalist 2, John Jay discusses whether the 13 states should become a new nation, one nation, or divide themselves into separate confederacies. Jay starts out logically with universal principles. Quote, "The people must cede to government some of their natural rights in order to vest it with requisite powers," meaning powers to protect the rest of their natural rights from being endangered. This is what I call the form, the template for good government, the idea of natural rights. To that extent, Jay and the founders were propositionists. However, these true but abstract principles, the form, are not enough. The people have to be capable of liberty. They are the matter. That is why Jay proceeds to discuss whether this particular people living here in North America is capable of sustaining liberty and political unity. Jay says yes for several reasons, only one of which is agreement on the form, the principles. He also adds that Americans have the same ancestors, meaning the same race, the same language, the same religion, and similar manners and customs. These accidents of our colonial inheritance, that is, our particular matter at the time of the founding, made Americans well-suited to be citizens of a free nation. Religion and culture, therefore, do matter, even in a nation based on a universal truth. Gouverneur Morris, and I'll give you 3 examples of quotes from the founders on this point. Gouverneur Morris thought the French of the 1790s incapable of the vigilant self-assertion that is a condition of liberty. Hamilton thought that no, quote, no regular system of liberty will at present suit Haiti. The government must be military, unquote. In his old age, even Jefferson wrote, quote, whether the state of society in Europe can bear a republican government, I doubted when I was younger, and I still do now, unquote. Neoconservatives love to quote Tocqueville. How many remember, though, that Tocqueville's judgment that the United States is the only nation in the Western Hemisphere capable of supporting a democratic government? Fourth misunderstanding is the belief that the natural rights theory does not provide clear guidance on foreign policy, or that it is open to the kind of foreign policy that Americans follow in our time. I would say that is wrong on both counts. There are two main principles that guide foreign policy in the founding, both stated at the beginning of the Declaration. One is government must secure these rights, which most obviously is achieved by protecting citizens against the violence that might come from other nations. It must deter or defeat attacks, in other words, on life, liberty, and property of Americans by means of armed forces, diplomacy, alliances, and so on. And that would include protecting American commerce, so not purely limited to our own borders. Second principle of the Declaration is non-intervention. All nations, in the first paragraph of the Declaration, have a right to, quote, the separate and equal station to which the laws of nature and of nature's God entitle them, unquote. Taking these two principles together, government's job in foreign policy is first, secure the citizens' rights to life, liberty, and property by defending the nation, while second, refraining from interference in other nations because of the natural law obligation to respect each nation's right to a separate and equal station. This declaration, in its conclusion, sums up this approach to foreign policy by saying that we will now, from now on, we will hold Britain as we hold all nations, enemies in war, in peace, friends. No matter what your form of government, we will regard you as a friend unless you attack us, is in effect what is meant by that statement. There are important exceptions, but I will leave that for later. This view of foreign policy is considered today to be libertarian or isolationist, and I would say it is rejected by most liberals and most conservatives. Fifth misconception about the founding. Scholars rarely notice that in domestic policy, government secures our rights most obviously by making and enforcing criminal laws against violence and other depredations. Jefferson explains that, quote, that because, quote, wicked and dissolute men commit violations on the lives, liberties, and property of others, government would be defective in its principal purpose were it not to restrain such criminal acts by inflicting due punishments, unquote. Note Jefferson's phrase, its principal purpose. That is what government is for, protection against harm to life, liberty, and property. These are our natural rights. Government today has different priorities. In Houston, 20,000 burglary, theft, assault, and hit-and-run cases with workable leads were not even investigated in 2013, according to a study that was made in that city. Also in Texas, up until quite recently, Texas judges have routinely punished first-degree murder with probation and no jail, no prison time. In 2014, it took an act of the state legislature to change, and they refused to change otherwise. 2014, in Detroit, 5 years after it had been found out that there were 11,000 abandoned rape kits in Detroit, in a Detroit warehouse, 5 years later, only 2,000 of these had undergone DNA testing. Memphis, Tennessee had a backlog of 12,000 untested rape kits in 2014. People living in large cities today typically get much less effective law enforcement than we do in Hillsdale. These lapses represent a tacit rejection of the founders' approach. Our priorities today go to expenditures of vast sums of money on bureaucracies, transfer payments for education, welfare, medical care, and exasperating involvement in the details of the governance of private associations. I conclude with our question, is the founding conservative, liberal, or libertarian? My answer is none of the above. Thank you.
Well, Thanks, Tom, for that. Thanks, Dave and Heritage Foundation for having me for this. Let me get the most important thing out of the way first, and that is that this is a wonderful book. You should buy it, and you should read it. And everything else is just going to be superfluous to that. I've never had such a hard time coming up with a critical commentary to make about a book as I've had on this one, because I find so little in it to disagree with, except for quibbles, and quibbles don't make for very good comments. As my contribution here today, and as a way of answering the debate question or the topic question of whether the founding was libertarian, conservative, or liberal, I'm going to talk a little bit about what the book doesn't do as opposed to what it does do. And it's sort of surprising what it doesn't do, because you would think a book that was entitled The Political Theory of the American Founding, Natural Rights, Public Policy, and the Moral Conditions of Freedom would tell us a lot about the United States Constitution. That would seem to be a pretty obvious reason why you'd read it and why you'd buy it. But it turns out the book says almost nothing about the United States Constitution. It is about the political theory of the founding. That's what it's about, and it disabuses or it goes after people who have attempted to characterize the founding as either liberal or Republican, meaning liberal meaning individualistic, or Republican meaning communalistic, or some amalgam of both. It's a very, very effective critique of that. But it doesn't tell us that much about the U.S. Constitution, does not purport to, doesn't even really talk about the Constitution all that much. Its evidence is primarily drawn from state constitutions, not from the U.S. Constitution. But I think it has some implications for the U.S. Constitution, and that's what I want to mention. And I think those implications are, on balance, libertarian, although I would qualify that. So here's the major implication. In my book, Our Republican Constitution, I start with the Declaration of Independence, and the Declaration of Independence that states the purpose or political theory of the United States government that is then embodied in the Constitution, and that is, we hold these truths to be self-evident, that all men are created equal, endowed by their Creator with certain unalienable rights, among which are the rights of life, liberty, and the pursuit of happiness, and each one of these are individual rights. The individual right to life, the individual right to happiness, to liberty, and the individual right to the pursuit of happiness. They're not collective rights, they're individual rights. And then the next sentence says, to secure these rights, governments are instituted among men deriving their just powers from the consent of the governed. So that states the purpose of government, and I should say it states the only purpose of government. It doesn't state another purpose of government. It states the purpose of government is to secure these pre-existing unalienable rights. And then the question is, well, how representative is the Declaration? How true is the Declaration? Am I reading the Declaration accurately? This book is a reaffirmation of the accuracy of reading the Declaration the way I just said, which is that natural rights, the unalienable rights of life, liberty, and the pursuit of happiness are natural rights. They are a succinct definition of what natural rights are. There are little more expansive definitions of natural rights found in state constitutions at the time, primarily those that using wording that was authored by George Mason for the Virginia Declaration of Rights. But nevertheless, the Jeffersonian version, copied in some sense from the Mason version, is a perfectly good one. And this is the purpose of government. That's what this book demonstrates, that the purpose of government is to secure natural rights. So that suggests a libertarian component to the founding and to the U.S. Constitution, an individual rights component to the founding and the Constitution. But it doesn't end there. What then is the purpose of a Constitution? Well, the purpose of a Constitution is to limit government to its proper powers, to limit government to the purpose for which it's established, which I've just said is the protection of these individual natural rights. Now, we understand pretty well that the federal government, the original meaning of the Constitution, dictates limits on the power of the federal government. Conservatives of almost every variety will agree with that. There's a limit in enumerated powers, even though these limits have been overcome over time. But then what about states? That's where the disagreement starts to arise. You could see that the national Constitution is pretty libertarian. It doesn't really give Congress the power to mess around with very much that a libertarian would disagree with. But what about states? Now this is where the debate starts. Are state governments of unlimited powers that can do whatever they want, or are state governments limited by the same ends that the Declaration tells us that all governments, including the federal government, are limited by? So this brings us into a debate that was held in a case called Calder versus Bull. It was a Supreme Court case that divided two justices who both agreed on the outcome of the case. I won't go into the facts of the case. And the two justices that disagreed were Justice Samuel Chase and Justice James Iredell. And I just want to read a quote from Justice Chase's opinion in Calder versus Bull, because I think it's an opinion that is substantiated, primarily substantiated by Tom West's book. So here's Justice Chase talking about, now he's talking about the limits of all governments, any Republican government, not just the federal government. He says, I cannot subscribe to the omnipotence of a state legislature, or that it is absolute and without control, though its authority should not be expressly restrained by the Constitution or fundamental law of the state. In other words, that it's uncontrolled unless there's an express prohibition, which was Iredell's position. The people of the United States erected their constitutions or forms of government to establish justice, to promote the general welfare, to secure the blessings of liberty, and to protect their persons and property from violence. The purposes for which men enter into society will determine the nature and terms of the social compact. The purposes for which men enter into society will determine the nature and terms of the social compact, and as they are the foundation of the legislative power, they will decide what are the proper objects of it. The nature and ends of legislative power will limit the exercise of it. This fundamental principle flows from the very nature of our free republican governments. There are acts which the federal or state legislature cannot do without exceeding their authority. There are certain vital principles in our free republican governments which will determine and overrule an apparent and flagrant abuse of legislative power as to authorize manifest injustice by positive law, or take away that security for personal liberty or private property, for the protection whereof the government was established. And here comes the more famous line of this opinion. An act of the legislature, for I cannot call it a law, contrary to the great first principles of the social compact, cannot be considered a rightful exercise of legislative authority. The obligation of a law in government established on express compact and on republican principles must be determined by the nature of the power on which it is founded. So there you have Sam and Chase, one half of a debate on the Supreme Court, and yet I think Tom West's book completely substantiates Chase's view as to what the purpose of government is. So if all governments are limited by their purposes, then what are the limits of, and we know what the purposes of the federal government is from the enumeration, what are the purposes of state governments? Well, here's where things get complicated for everyone, including for libertarians. Well, for sure, the protection of health and safety is included in the protection of the individual natural rights of the person. So state legislatures have the primary responsibility for protecting the health and safety of the individual public. But then, as you all know, the police power is then said by some, and not infrequently, to extend not only to health and safety, but to health, safety, and morals of the general public, or health, safety, general welfare, and morals of the public. So then the question is, are morals included in the general end of state powers? As long as we were concerned with health and safety, we've got a really pretty libertarian constitution going, both at the federal and state level. Once you add the regulation of morality, then it becomes a little potentially less libertarian. But then it turns out there's an ambiguity as to what is meant by morality. And this is probably the last thing I'll have time to talk about. And that is the distinction between what might be called public morality and what might be called private morality. Not that it was necessarily called that at the time of the founding, but public morality are acts that take place in the public view and that affect the ability of the public to enjoy their life, liberty, and property. So, for example, acts that would take place in a public park, on a public street, acts that would be public and notorious. And I will just add this one quote that is in Tom's book on page 232 from James Wilson's lecture on law, which discusses this. So let me just almost finish with this quote. I have one more point to make after that. And here's Wilson now. There are some crimes and offenses which attack several of these natural rights of individuals. So notice Wilson connects up these morals offenses with natural rights. That's where I say things get complicated for libertarians. There are some crimes and offenses which attack several of these natural rights of individuals. They are a collection of personal injuries which annoy the citizens generally and indiscriminately. Public peace and order and tranquility and safety require them to be punished or abated. Disorderly houses are public nuisances. Indecency, public and grossly scandalous scandalous may well be considered a species of common nuisance. Profaneness and blasphemy are offenses punishable by fine and by imprisonment. And now here is Tom's explanation of this, which I think is a good one. My explanation, Tom's explanation, for Wilson's list is that disorderly houses, houses of prostitution, and public indecency threaten the public peace and order because they make public what should remain private. Public sale of sexual favors and display of sexual organs attack one of the moral foundations of stable marriage, namely the conviction that sex should be shared privately by a married man and woman. So here is where we are. Libertarians can, I think, quite happily add the protection of public morality or the protection of morality in the public sphere to the health and safety of the community without any problem, because the government needs to manage that for the benefit of the general public for which it's the agent. The only question that arises, and now I don't have enough time to talk about it, is what the impact of this is for moral conduct behind closed doors, in private. Moral conduct that is not flagrant, outwardly abusive, or in any way offensive to people, unless they just are offended by the knowledge it might be happening, but they don't actually have to confront it in their everyday lives. That is what the debate is truly about, and here is the ambiguity of the book. Tom does not consider whether such laws are considered to be constitutional at the time. He does note that such laws did exist. He also notes they were almost never enforced. And so that is the challenge for those of us who are trying to figure out what the appropriate scope of the legitimate police power of states are. What do we do about the fact that laws were ostensibly on the books at the time of the founding, but that they were never enforced, and therefore they were never really tested against the proposition that all government must be limited, and all government must be connected to protecting the individual and natural rights of the people, including that of the general public. And it's not clear to me that going after actions that are purely private and behind closed doors fits that criterion. Thanks.
That, ladies and gentlemen, is an impossible act to follow. And I won't even try. But I am, I am inspired to call an audible on myself at this point, because the first point I was going to make is, the first in a long list of points where I agree with Tom West. This may surprise many of you, but in fact, I can go a long way down the road with him. I do agree, for example, that the right way to look at the American founding, all things considered, is to view it as the founding of a natural rights republic. But there's an ambiguity. As I walked in, I picked up this handy-dandy little volume, and let me just briefly explain the ambiguity. What does it mean to be a natural rights republic? Well, some familiar words. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these, two critical words, among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the government. What is the meaning of the phrase, these rights? Does the phrase refer to the Holy Trinity? Or does it refer to the broader, although unenumerated in the Declaration, phrase, certain unalienable rights, which includes but goes well beyond life, liberty, and the pursuit of happiness? And I think in order to understand what it means to found a natural rights republic, we need to have a view on that question. And I'd be actually very interested in both Tom and Randy's view on that question. I think I know something about Randy's view based on his prior work, but Tom's I'm not so clear. So that's the first point of agreement with that ambiguity. Here's my second point of agreement. When we're talking about the American founding, we're not just talking about institutions. We are also talking about the character of a people, a character shaped by both moral virtue and religion. I absolutely agree with that. Third point of agreement, that, unlike some views or some interpretations of Scottish moral philosophy, we're not talking about innate virtues. We're talking about a capacity that needs to be cultivated. And then the question is, cultivated where and by whom, under what authority? And this begins to sidle up to some of the questions that Randy was posing. Fourth area of agreement, that the constitutional founding established a rough division of labor, which corresponds roughly to Tom's distinction between form and matter. That the constitutional form was principally established by the federal Constitution, and the matter, that is to say, the formation of the character and virtue of the people, was principally left to the states. I think that's a fair statement of the situation that was established by the founding. So let me give you an example of this division of labor. Tom comments, I think on page 94, that education was not a constitutional power of Congress except for the federal territories, close quote. That is to say, education, which was an important locus of character and virtue formation, was left to the states. Now, I have to say in passing that mischievous minds, and perhaps I have one, might ask on what authority George Washington proposed to the Congress the establishment of a national university. This is an interesting question. Washington's language is interesting. This is from his 8th and final presidential address, where he says, "Among the motives to such an institution, the assimilation of the principles, opinions, and manners of our countrymen, but the common education of a portion of our youth from every quarter well deserves attention. The more homogeneous our citizens can be made in these particulars, the greater will be our prospect of permanent union," etc. It's a very interesting statement that I commend to your attention if you have some spare time. And this question becomes all the more interesting when one considers a not very well-known fact, and that is that in September of 1787, James Madison actually proposed that the ability to found a national university be among the specific enumerated powers of Congress, and the Constitutional Convention rejected that proposal. Nonetheless, George Washington was very comfortable proposing to the Congress the idea of a national university, and he may be supposed to have known something about the Constitution given his role as the presiding officer at the Constitutional Convention. Now, I want to dwell for just a minute on some problems. How much time do I have left? 5 minutes, great. Some problems with this thesis of the division of labor between the federal Constitution and the state Constitution. And it's not a static story, it's a dynamic story. What I have in mind here is a concept that I have called regime effects. What I mean by that is that the example set by the federal Constitution had important spillover effects to the states. The federal Constitution helped to shape state constitutions and states' understanding of their appropriate liberties and powers, and this has consequences over time for the form and matter distinction that corresponds to the distinction between federal and state, at least roughly. Let me give you a couple of examples, both drawn from the sphere of religion. On page 210, Tom comments regarding religious tests for for public office, in spite of their broad early acceptance, religious tests were already in process of abandonment during the founding. Let me try to lend a little bit of historical precision to that generalization. As you know, when the revolution broke out in 1776, every one of the colonies, I believe without exception, ripped up their old constitutions and engaged in an orgy of constitution making. And some of them went through 2 or 3 iterations of the new constitution before they ended up with something that they were happy with. And so in these new constitutions established between 1776 and 1789, 11 out of 13 state constitutions had religious tests for public office. The only 2 exceptions were New York and Virginia. And against that backdrop, the federal Constitution's declaration that there shall be no religious test for public office represented a revolutionary break, not only with the states, but with all prior constitutional thinking. And the British Constitution, unwritten as it was, did not abolish religious tests for public office until the 1850s, for example. But immediately after the adoption of the federal Constitution, the states began abandoning the religious tests that they had instituted in the 13 years between 1776 and 1789. And I have looked at historians' study of this abandonment, and there is a general consensus that the federal Constitution had an effect on what the states understood to be appropriate conduct at their level. Another example in this same vein would be religious establishments, where the federal Constitution, and I'll summarize a lot of history here, had a very clear impact on state establishments, which were nearly ubiquitous during the founding period. So what happens when the federal Constitution has what I'm calling these regime effects on the state constitutions? The answer is that the federal Constitution's understanding of the limits of state power affects the state's understanding of their appropriate exercise of what is known as their police powers. And so you might argue historically that the federal Constitution over time had the effect of making the state governments more libertarian than they were at the outset, of cabining their sense of appropriate police powers. One point in conclusion, and Tom may want to comment on this, has to do with the founders' understanding of religious liberty. I was a little bit surprised that Tom characterized James Madison's memorial and remonstrance as a, quote, extreme and intemperate document, 2 adjectives that you used on page 204, because in fact, contrary to Tom Pangle, the other Tom in this space, and a number of others, I do not regard it as illogical or poorly argued or extreme or intemperate. I regard it as the most fundamentally sound statement of the principles of religious history in American history, of religious liberty in American history. And I don't regard it as an outlier. Here's a quotation from the Delaware State Constitution, which I could supplement with a number of others. Quote, "No man ought or of right can be compelled to attend any religious worship or maintain any ministry contrary to or against his free will or consent, And the phrase maintaining a ministry means publicly subsidizing a ministry. And Tom says that the Memorial and Remonstrance is an extreme document because it fails to distinguish between religious liberty on the one hand and the prohibition on public contributions to ministries on the other. But in fact, that was by no means an outlier's view during the founding period, and it is certainly not an outlier's view today. James Madison's view, I think it's fair to say, has prevailed, and justly so.
Tom?
Okay, yeah, I'll just, I can't respond to everything said. I appreciate the remarks on both, coming from both sides here. Helpful, bringing up good questions. Maybe I'll start with the last first, Madison. What I was objecting to in Madison, or Tom Pangle and I both had the same objection to Madison's argument, is that it was an argument that was too sweeping for what it was trying to achieve. That is, Madison wanted to make the claim that government should take absolutely no cognizance whatever of religion, which would mean not only that government could not support specific religious denominations, but if that principle were applied literally, the word God shouldn't be ever mentioned by any government official at any time or place. And that's kind of like that's more like what we think of as the European view of the sort of thing that as it exists now. My point in the discussion of religious liberty was there was a consensus about the primacy of freedom of religion and the importance of support of religion, but a tremendous battle over what form that support should take. And the forms of support that were dismissed and abandoned were the ones that were the most divisive, the ones that were specifically denominational, such as the religious tests and the for public office, and specific taxpayer support of individual religious denominations. The consensus came to be in the 1820s, 30s, and 40s that religion would be supported in a more generic way, either in the form of general religious principles of the type you find in the Declaration of Independence or Washington's various statements on this Thanksgiving address, or it'd be sort of a generalized Christianity, kind of general Christian principles without specifically denominationally distinguishing them from each other. So I do agree, religious tests were controversial. But as for the mutual influence of the Constitution, federal Constitution on the states, or rather, no, I'm sorry. Bill was suggesting the federal Constitution is more like the form shaping the matter of the state constitutions. My suggestion would be rather that both federal and state constitutions, which, by the way, were written by many of the same people, both before and after 1787, they were all trying to think through the question of how do we institute this regime of natural rights in a way that supports the moral conditions of freedom, while not being too offensive towards our fellow citizens. And that's one of the reasons I think why specific targeted support of individual religious denominations was abandoned quickly everywhere but in a few New England states. As for the question that Randy brought up on the question of public morals, is protection of public morals part of the police power of government at the state level? First of all, I would say it's also, yes, it is, and it's part of the police power at the federal level too, insofar as the federal government has responsibility for things that are not yet states, like DC or the territories. So, and this responds also to Bill's point about how do you understand a national university. My understanding is that it was supposed to be in DC, and it's part of the overall plenary power that the federal government has to govern DC in the way that the states would govern the states, and therefore would take into account things. So another example of this would be welfare policy in the Northwest Territories. One thing I discovered was that the Northwest Territories had a welfare policy created by Congress. It's not a normal power of Congress, but these are territories, and that policy was modeled on the existing policies of states like Pennsylvania and others, from whom many of the settlers there had moved. So there was some overlap, but in general, my point I was making about the two constitutions, the federal versus state, mostly it was just a division of labor. It was just like we're just telling the federal government, that's how we're doing foreign policy, and the only other thing the federal power was about really was some things having to do with establishing a national free market, breaking down state barriers to commerce. That was another big theme. And which included also state barriers to commerce insofar as they were creating inflated currency that was not reliable for transactions, of commercial transactions. So the federal government was going to take over the money question. On the question of public morals, I think the founders de facto accepted Randy Barnett's distinction between regulating private morals versus morals that have an effect on the public. And the quote from James Wilson that he read is supportive of that. That is, from Wilson's point of view, it's very much the public effect of immoral behavior that is a matter of concern to government, not what goes on behind closed doors insofar as that has no public effect. So I think that now, maybe you could say that from a legal standpoint, they should have made that clearer in the laws. But I think it has been a custom throughout our history often for law enforcement to follow custom at times when custom begins to diverge too far from existing laws. And that might be a case with regard to the, let's say, state law prohibitions on homosexual conduct. And it existed, but that provision appears to not have been enforced in the founding era, with a minor exception that can be explained as a different kind of situation, which I talked about in the book. And so, practically speaking, maybe it's not such a concern. Maybe it matters. Maybe that these laws were not enforced in regard to private situations. The other thing you'd have to think about is how would the government have come to know about private sins, let's say, unless somebody ratted them out, and then why? Then there's the question of social ostracism. Why are you poking around in other people's affairs and so on? I mean, there was a strong, I think, customary sense of respect for the private throughout that period, and so what you did in your private life, if it was not obtrusive in a way that was offensive to the community, was very much thought to be rightly left alone.
I don't know what the protocol is from here on. Is there going to be crosstalk on the panel?
Well,
or-
eventually, we want to get to the audience, but if you have something to say, by all means.
Well, not if we're running out of time for the audience.
I just wanted to add one thing. I mentioned during my talk that that Jefferson's version of the natural rights doctrine that's in the Declaration of Independence was not necessarily the canonical one. It was actually cribbed and condensed from Mason's draft, which had been drafted a couple of weeks earlier, and that Jefferson had a copy of in front of him while he was drafting the Declaration of Independence on a very short time horizon. He actually had he was on a lot of committees, had a lot of committee work to do. They'd given him 3 weeks to do it, but he had all these other reports he had to write. So he basically wrote this in a matter of a few days, and so he cribbed, and one of the things he cribbed from was Mason. And Mason's formulation went on to be adopted by several state constitutions and recited in various cases throughout history, like Corfield versus Corio, which talks about what the privileges and immunities of citizens are under Article 4. They use Mason's formulation. So I thought I would just read you what Mason's formulation is, but I'm not going to read you from the Virginia Declaration of Rights because they tweaked it a little bit to make it a little less threatening to slavery, perhaps. I'm going to read you from the Massachusetts Declaration of Rights, where John Adams, who wrote that, took Mason's draft language, which I think is interesting, that he would use Mason's draft language, not the final adopted language. So here's what how Massachusetts starts. All men are born free and equal. This is the born free and equal part that Virginia tweaked. All men are born free and equal and have certain natural, essential, and unalienable rights, among which may be reckoned the right of enjoying and defending their lives and liberties, that of acquiring, possessing, and protecting property, in fine, that of seeking and obtaining their safety and happiness. All of these elements are in the Declaration somewhere, but Jefferson divided them up and put safety and happiness elsewhere in the Declaration. So this would be, I think, the most reliable and consensus view of what the core of natural rights are. I realize, Bill, it still says among which, so you can hang your hat on among which.
Yes, I can.
But I think the reason for this sort of formulation is that if you view natural rights as essentially liberty rights, the rights to do what you will with what belongs to you, with what, not Hobbesian liberty, which is the right to do what you will, but Lockean liberty, which is the right to do with what you will with what's yours. If that's what you view natural rights to be, you can never limit natural rights because it's the liberty to do whatever you want within what's your appropriate jurisdiction, so it's limited only by your imagination. You could never have a definitive list of all the liberties you can exercise, like, for example, the liberty to raise your kids as you see fit, the liberty to get married to who you wish, all these liberties, these would all be subsumed under this more general heading.
Yeah, I'd only add two other natural rights that are often mentioned in founding documents. One is the right to reputation, meaning that, and that therefore there should be some sort of ability to get reparation when people libel you, harm your reputation in such a way as to make it difficult for you to live in the way you would like. And the other is religious liberty, which is also part of the same Virginia Declaration of Rights. It's just listed at the end.
Well, I would like to open it up for questions from the audience, so if you'll just wait until you get a mic from one of our interns. The young man in the front. And then you'll be next.
Hello. I was wondering, so to summarize your points, do you think that the founding fathers mostly envisioned that free speech, free press applied inside the states, even when it came to state governments?
Right. My understanding, I think all three panelists would agree with this, is that the founders' theory of natural rights was meant to apply to all levels of government. One of the comments I make in my book is that it's easy to get distracted on the issue of federalism because no matter which level of government was supposed to do what task, they all had the same idea about what the tasks were, and they were all defined in terms of this basic agenda of securing natural rights. And that would, of course, and of course, you could say, yes, freedom of speech and press, those too are natural rights, and sometimes were called such in the founding documents, all part of the basic right to liberty.
Thanks. Is there any indication that these rights are mainly for citizens or that they pertain to anybody who happens to be in the country for no matter what reason? Is there a distinction between the rights of citizens and non-citizens?
Definitely, yes. The founders definitely made a distinction between citizen rights and the rights of people who happen to be here. The basic, and of course this is codified in the 14th Amendment, Article 1, the basic rights of people who are here but non-citizens are protection of, equal protection of the laws and due process of law for those who accused, when the government wants to take away life, liberty, or property. So equal protection in the original sense, as I understand that, which is very different from today's judicial understanding, is the government must equally punish and prosecute and punish crimes committed against other people, and no matter who the crime is committed by and who the victim is. That's for everybody, not just citizens. And for citizen rights, that goes to the question of privileges and immunities of citizenship, which in the pre-Civil War period there was not a complete consensus on, but it generally included things like the right to travel within the United States, the right to dwell in any state, the right to open a business, the right to keep and bear arms, the right to freedom of assembly and publications. These things were thought of as rights not necessarily available to non-citizens, but always available to citizens, and that was part of the point of the 14th Amendment was to say that blacks are now from now on are going to be citizens, and they're going to have those citizens' rights protected.
And as going back to what I was saying earlier, when the canonical judicial definition of privileges and immunities of citizens was Justice Bushrod Washington's Circuit Court opinion in Corfield versus Coriel. And he had a lengthy paragraph on what those privileges and immunities, which he said it might be too tedious to enumerate, so he would just give you a general sense of it. And the core of what he quoted, not the whole thing, but the core of it was Mason's formulation of natural rights, which was at the heart. There were other rights he talked about as well, but clearly Mason's formulation of natural rights were among the privileges and immunities of citizens protected by Article 4. So that when you went from state to state, when a citizen went from state to state, they could not be deprived of these fundamental rights in another state just because they came from somewhere else.
I would only add that there are places in the Constitution where the phrase all persons appears, and that's a distinction with a difference.
Sir?
Thank you. Yeah, I have a real problem with this concept of natural rights because it seems like it really depends what one person considers to be natural rights depends on their world and life view. I mean, you could have 5 different people with different world and life views, and they'd have come up with different concepts of natural rights. I mean, a neo-Darwinian might feel he has the natural right to suppress the weak.
So he would be defining his own concept of existence, then, you would say. No, just all right. Go ahead.
It seems to me the focus, when we're looking at the American founding, the focus should really be on the world and life view of the founders. It's that view that gave rise to what they considered to be natural rights. So shouldn't the focus really be on their world and life view?
Well, the concept of natural rights, natural law, is that there are certain truths about the human condition that are always there. They're not always known, but they're always there, and they can be discovered by reasoning about the human condition, and that it's always better to be alive than dead, and therefore that it's bad to kill people, or it's better to be free than unfree. It's wrong to enslave people. That's what they meant by natural rights. And I do agree with you that today, the people in politics today often like to say, I believe in natural rights too, and therefore we need Obamacare or whatever it might be. So yes, the term today is susceptible to the kind of thing you're talking about. And maybe, as some say, that it's not possible to revive anything like the founders' understanding because people today don't know what it is. I mean, it took me 400 pages to say what it was, and I don't expect people to be reading that for the most part. But you're right. You have to understand what they meant by it. You have to get back into the way they thought about human nature and what government is for, and why we need these kinds of policies. Like, for example, rules punishing murder and kidnapping, or why do we need contract law? That's not self-evident, but that's part of their view of how government protects natural rights, enabling people to exchange goods and services so that people who are poor can acquire wealth, right? They sell their labor to somebody else. They acquire things, and they can then invest. So all the things government has to do to secure natural rights, many of them are not at all self-evident. And it's part of why it took a while for me to explain it in the book, is that it's a pretty complicated picture, and in many ways it's a forgotten picture. That's why the book has on its cover a faded and tattered picture of the Betsy Ross flag. Right? That's kind of the state of our understanding of the founders' political theory.
If I could just elaborate on Tom and the book, you have to distinguish 2 different things. What were the founders' conception of natural rights, and was that conception correct or not? Is it the right one? And Tom's book is about the first of those questions, not so much about the second of those questions, though he does suggest in places where I think he likes what the founders thought. So I think at this point, what we're really debating about isn't whether there are competing conceptions of natural rights, because nowadays there would be, but only as an empirical matter, what did the founding generation mean when they talked about natural rights? And this is a book about that.
And if you look at the language of the Declaration, it strongly supports that view. If you look at the phrase, we hold these truths to be self-evident, the word we does some real work, right? Because it's entirely possible that others would not consider them to be self-evident. even though from a certain philosophical point of view and a certain understanding of self-evidence, it would be true universally and not particularly. And you also have Jefferson's famous letter in which he talked about the harmonizing sentiments of the American mind, as lying in back of his formulation in the Declaration of Independence.
Well, I think we're going to adjourn.
There's a
Thank
quick-
you very,
Yeah,
but we are,
Oh, okay.
because of time, and you need to run and do an interview too, Randy, so.
Okay. In that case, let's adjourn. Come on, let's go.
Thank you very much, everyone. Thank you.
Good job, Bill.